Welcome to the lesson on the Separability Thesis in Hart and Raz. As usual, the learning materials for this topic can be found in the description below the video, in order of appearance. This lecture considers one of the central debates in jurisprudence, the relationship between law and morality. We will examine the views of Hart, often described as a soft positivist, and contrast them with the exclusivist or hard positivist position associated with Joseph Raz. Hart's well-known attempt to defend the separability thesis, that law and morality are not necessarily connected, has been misunderstood. What Hart offered was not an endorsement of unethical legislation, but a normative argument about how legal systems ought to operate if they are to remain coherent and capable of functioning. Raz, by contrast, insists that legality must never depend on moral reasoning. For him, although moral principles may be used instrumentally, they do not and cannot provide legal validity. By exploring both positions, we can see clearly how positivists attempt to understand the nature of law, rather than prescribe how it should morally behave. Hart's project sought to articulate the conditions under which law can be clearly distinguished from morality. He famously claimed that there is no necessary connection between law as it exists and law as it ought to be. That statement is often taken to mean that Hart believed law should abandon moral considerations entirely. In fact, Hart was making a subtler point. When we examine the concept of law, we must do so on value-neutral grounds. This is not because law and morality never interact. Hart quite openly accepted that they do, but because the nature of legal authority can only be explained by examining law as a social institution rather than as a moral ideal. As Leslie Green observes, morality sets standards that law often wishes to emulate. A legal system may aspire to align itself with moral values, but this does not mean that law necessarily reflects those values. Hart's insistence on separability therefore concerns analysis, not moral indifference. A recurring criticism from natural lawyers is that positivists fail to recognize that legal reasoning is inherently moral. Hart's response was that positivists are not seeking to provide a moral guide for judges or legislators, but to understand what law is. Whether law should be moral is a separate matter. The analytic question must be kept distinct from the normative one. Another important point made by positivists concerns the autonomy of the separability thesis. They argue that it stands independently from the claim that legal systems consist only of positive law. In other words, even if moral principles occasionally influence legal reasoning, this does not collapse the distinction between the source of law and its moral worth. The separability thesis has been contentious. Some argue that it cannot distinguish positivism from natural law because the thesis is either universally accepted or universally rejected. Others maintain that while the thesis is coherent, it is nonetheless false. Yet Leslie Green suggests that Hart demonstrated compelling reasons, both moral and pragmatic, for adopting a value-neutral approach when analyzing legal systems. One of Hart's pragmatic reasons relates to how obligations arise. For him, obligations do not stem simply from threats, a point that distinguishes him sharply from Austin. Rather, obligations arise when social rules generate expectations of conformity. As social pressure increases, individuals feel compelled to comply, not necessarily out of fear of punishment, but because they recognize the practice as binding. However, Hart also acknowledged that these impulses can sometimes resemble moral motivations. People may comply with legal obligations not merely because of social pressure, but because they believe the rules serve important social interests. This blurs the apparent boundary between moral rules and legal rules, but Hart insisted that the degree and nature of the sanction differentiates the two. Legal sanctions tend to be more severe and more institutionalized, whereas moral sanctions are diffuse and less coercive. For Hart, this qualitative difference is significant enough to defeat the argument that law and morality operate synchronically. Hart also recognized that moral obligations typically involve an element of self-sacrifice, highlighting the internal conflict between self-interest and duty. Legal obligations can generate similar tensions. Yet Hart maintained that these overlaps do not undermine his central claim, that the concept of law does not depend on any necessary moral criteria. Importantly, he accepted that individuals internalize the norms of the groups to which they belong. When this happens, a person shifts from feeling obligated to obey, to feeling obliged in a more voluntary sense. That observation echoes aspects of Finnis's argument that moral underpinnings are often present even when we do not expressly acknowledge them. Raz's theory represents a more uncompromising form of positivism. While Hart's approach allows for a degree of overlap between law and morality, particularly when we consider how obligations arise, Raz argues that the validity of law must never rely on moral reasoning. In his view, the law must be understood entirely through its institutional sources. Judges may, from time to time, rely on extra legal standards, but Raz insists that this does not give those standards legal authority. Exclusivists accept that judges occasionally draw upon moral considerations, but they treat these as tools serving the existing legal framework rather than as independent sources of law. If moral reasoning enters judicial decision-making, it does so only because legal convention allows or requires it. Raz emphasizes that moral rules, even when considered by judges, do not become legal rules simply because a court engages with them. He likens moral principles to foreign rules that courts sometimes apply. Judges in one jurisdiction may apply foreign law without granting it domestic validity. The same holds true for moral principles. They may be invoked, but they do not generate legal authority. This analogy underpins Raz's insistence that moral reasoning cannot form part of the criteria of legal validity. Raz also argues that the rule of law has no intrinsic moral content. For him, the rule of law aims at value neutrality. It structures how power is exercised rather than ensuring that power is exercised morally. That said, Raz acknowledges that legal systems intersect with morality in several ways. He offers 3 examples. First, he agrees with Hart that legal systems must protect life and property if they are to function at all. Secondly, law can sanction what is morally reprehensible. This means law can become a vehicle for immorality, depending on how institutions behave. Raz illustrates this with an intentionally stark example. Although the law cannot commit rape as only a living being can perform the act, legal institutions can certainly facilitate immoral conduct. Thirdly, given the existence of value pluralism, no society can embody all virtues or vices in full. Law must navigate this plurality without claiming comprehensive moral authority. In conclusion, Hart and Raz disagree on how far morality can influence legal authority. Hart accepts that morality shapes human behavior and often informs rule following, but he maintains that the concept of law can be analyzed independently of moral evaluation. Raz, by contrast, stands firmly against moral criteria being part of legal validity. Judges may draw on moral reasoning, but such reasoning remains external to law's authority. Together, these theories illustrate the breadth of positivist thought and the complexity of analyzing legal systems in moralized societies. Their debate remains central to contemporary jurisprudence, a reminder that understanding law requires us to distinguish what law is from what law ought to be. Thank you for your interest in this topic. To learn more about law and morality, check out our dedicated video lectures. We hope that this lesson was helpful to you and are looking forward to seeing you again soon.